My name is Brian Mayer. I'm an attorney practicing family law throughout Southern California. And the question I'm going to answer today is what happens when a parent tries to move their child out of state without the permission of the other parent and before uh, a petition or any sort of filing has been made in court that relates to child custody. Now, this actually comes up a lot. A lot of times, the when a marriage or relationship breaks down, one of the parents feels like they do not have the support that they need wherever it is that they're located now that they've lost their spouse or significant other, and they want to move somewhere where they can get support. And for example, I'm going to use an example. Let's say someone is living in California and they want to move back to visit their family in Idaho. Okay, so for the purposes of this discussion, let's say that dad works in California, mom has been living there with their son together, and mom wants to move back to be with her family in Idaho along with her son. And so basically, here's how it works. Okay, California is one of 49 states that is part of what's called the Uniform Child Custody Jurisdiction Enforcement Act jurisdictions. And what it is it used to be back in the days of the Wild Wild West, it used to be that if someone took their child and moved them over state lines, it created this whole mess as it relates to child custody jurisdiction because sometimes both states would claim jurisdiction, sometimes neither state would claim jurisdiction over the child. It was sometimes the state that they're moving to would claim jurisdiction. Someone moves from Florida to Alaska and they're there for one day and they file in Alaska, and now the parent left behind in Florida is trying to fight for custody in Alaska court. And it was crazy. So 49 of the 50 states got together and they came up with this agreement, and they all passed essentially the same law into effect as it relates to jurisdiction. And the way it works is that it creates something called the home state. Okay, the home state is different from the state of jurisdiction. I'm sorry, the home state is different from the state of residence. Okay, so what that means is if you live in California and you take the child and you move them out and you register them in a school, you claim a new address. For yourself, you get a driver's license for the new state, but you've only been there, say, 3 days. Okay, you're probably not going to be able to call the new state as your home state. Okay, so what we're talking about is this home state establishment, and the home state is the state that has jurisdiction over child custody. Now, really, what is the home state? The home state is where the child resides and where they're permanently going to stay. But when a child is moved to the state and they've been there for less than 6 months, then the question of original jurisdiction for this child custody matter is going to stay back in the other state as long as the other parent opposes it. And there's not really a bright line rule. One could argue if, for example, let's say it's been 5 months, mom has moved the kid to Idaho. Dad hasn't said anything in opposition, but he hasn't gone along with it either. And at 5.5 months, then he files for jurisdiction in California. Mom could make the argument that Idaho is now the home state, but the problem for mom is that because it's less than 6 months, then she's going to have to explain why Idaho is truly that child's home in their home state now and not California, even though it's been less than 6 months. And even though the statute says that it's not until 6 months that you have that certainty. So really 6 months is kind of the magic cutoff there. If mom moves to Idaho with the child and she's been there for 6 months with the child, claiming that as her home and the child's home for 6 months, she's pretty much going to be in the clear. Idaho will be the state of jurisdiction. If dad wants to file for custody, he's going to have to fight it out in Idaho where mom moved. If it's less than 6 months, mom's going to have an uphill battle. She may very well end up in a situation where she is in Idaho trying to fight for custody back still in California. And she may even have a situation where she has to return the child to California until long-term custody has been decided. And that obviously is going to be a gross inconvenience for mom. So the question is, what do you want to do then? What do you do if you want to move out of state with your child and no one has filed for anything yet? and you want to move to another state, you want to file there after 6 months or has passed, and you're just worried about what's going to happen. Well, you have two choices. First of all, you can go ahead and take the gamble and move to the other states and hope that the parent left behind just doesn't file in the meantime. It's a gamble. You could move out there after 2 weeks and then the other parent files, and then you're fighting for custody back in the state that you just left. It may not be a big deal if you're moving from Rhode Island to Connecticut, but if you're moving from Florida to Washington, it's going to be a big deal. The other option is to just go ahead and preemptively file for custody in the state where you are and hope that the court gives you permission to let you move away. Now, I will say this. If you're worried that the state that you're in may not grant you permission to move away, then you should continue to have that worry if you move away and hope that the parent behind doesn't file to keep custody there. Because if it makes sense to keep custody in the state that you're leaving, it's going to make sense to keep custody there for as long as that state has jurisdiction in most cases. Every case is different, and it's not a bright line rule. You really kind of have to just look at your situation and say to yourself, okay, how big of a deal would it be if I move out of state, the other parent files for custody sometime in the next 6 months back in the home state, and then I have to go back and fight for custody from there. If you think it's worth the risk, you can go ahead and do it. If you don't think it's worth the risk, then you're probably going to want to file and request permission to move before you move. But it's one of those things where it depends on what the other person does. So there's not necessarily any great answer. We don't have any crystal balls. It's just a matter of risk. The least risk-averse option is to go ahead and file before you move, because then you at least are certain about where things are at that moment, even if you don't know the outcome. Either way, you may not know the outcome, but at least if you file in the state where you are, you don't have to worry about moving the child and then moving the child back, sometimes even possibly months later. So I hope you found that helpful. Again, my name is Brian Mayer. I'm an attorney practicing throughout Southern California, and thanks for watching.